Give me just. Okay. So chapter 7, liability and student records. A lot of it hinges on like the FERPA laws, which is Family Educational Rights and Privacy Act. It's intended to kind of give students and parents rights when it comes to the information that schools collect and distribute, and as a whole, it allows parents and students access to those educational records that schools collect, and it also um, limits what schools can put out there as far as information collected. And head to the next slide.
It's not moving. There we go.
There we go. So, and some of the basic information, it was called the Buckley Amendment, did it in 1974. But in schools, kind of in my former role, one of the things we did with FERPA that constantly came up, and I think we all have a general understanding of FERPA. When we hear the term FERPA, we think of, not releasing student records and not sharing information. And one of the things we used to do is I'd evaluate software programs, and that's anything from Canvas to Infinite Campus, or a lot of the student information systems or software that a student is going to use in class, or a teacher is going to use to instruct. We wanted to make sure that those companies took student privacy seriously, because a lot of them will, the internet, they collect data on you whenever you click on something. So we wanted to work with companies that had a really solid policy on protecting student privacy and student information. We didn't want to have to upload, birthdays and emails and everything in order for a student to use this software. So a lot of the programs we used had really solid FERPA compliance, and we wouldn't work with companies that did not. Another thing we did as in the school district, is we took a lot of care in preventing unauthorized access to student information. And so some examples of that: only the teacher of record had access to grades and a lot of the information. It wasn't accessible by everybody in the school. So that would include, like, a common one, AEA staff, or I guess in Nebraska you call it ESU staff, did not have access to everything. They'd have only basic information on students. So in Sioux City, it's a pretty large school district. We just took great care to not allow access and not let that information out, I guess. So only people who need to know have that information. So my question to the group would be, what experience, as a teacher or wherever role you are, where does FERPA come into play with anything in your daily working as a teacher?
So the first thing that, when you're kind of going over the first few slides and then just reading the chapter that we had, I guess as a teacher, we don't really understand FERPA in depth. I guess I always thought of it more as, the kids even understand it as, you don't share each other's grades, you don't give out people's personal information, and that's just the surface of it. But like you talked about, having programs that schools can buy to really safeguard students' real information. I'm just thinking grades and stuff like that, but you're talking birthdays and parent information and street address. So there's a lot of information that, FERPA is there to help protect, that just the average teacher, I don't think quite understands, because I know myself, I don't quite understand it yet, since I'm not an admin yet.
Yeah, I'll touch on this a little bit on some of my section, but I'm a reading specialist. So since I'm not a classroom teacher, I do not put in grades. I don't have an assigned list of students, kind of changes throughout the semester and different semesters. And so I am not given access to, ours is called NEBSIS. So I don't get access to that, which as a reading specialist, sometimes kind of hard because I'm like, well, I want to know the contact of the students I do service because I want to contact those parents and have open communication. And I also look at a lot of data as a reading specialist, but every time we kind of have asked for that access, the district administration has always pushed back of like, if we give you that access, then you're going to be able to see all students' information, and those are not even the students that you service. So we've kind of always had kind of a back and forth between, what can we see, what's confidential, and what we can't. So I think that, I don't know, and I know some districts, they do let their reading specialists have like access to see that information. So I don't know how that sometimes fits in with FERPA exactly, because I am still a certified teacher who has, their educational interest at heart, but I don't maybe service all the students that I could see in the program.
We also use NEBSIS, and I mean that has everything from grades to medical history to special comments about custody, and things like that. And I know at our school it is just the teachers and administrators who have that. For my own experience in the classroom, it's kind of interesting. I always would make like class Quizlet sets and things like that. I teach 7th grade social studies, and as of last year, they told us that we can't use Quizlet with the kids because they have to enter their date of birth to make an account in order to access things. So that kind of I understood, but also it was kind of tough to work around for me as a teacher. It kind of changed the way I do things. So that's kind of how it has affected me.
Interesting. I didn't really, I don't know what it looks like from the student perspective of Quizlet. So I guess I never really realized they had to put their birthday in there. So
yeah, they have to give their school email.
okay.
They also have to give their date of birth, and because of that,
Gotcha.
it's on our banned list.
Is that, it must have something to do with some sort of verification, I guess.
Yeah.
But we're a small private school, and actually we locally in Fremont, we have a company called Sycamore, which is like a great value brand of power school, I guess I would call it. And I'm just a teacher. I'm not an administrator at all. I'm not a counselor. So I don't have access to everything. Like I know, like our guidance counselor, our principals have like, they can pull up missing assignments for each student. If I were to pull up a kid in my class, I could have access to their overall grade and some of their personal information, like addresses and medical history, but I don't have access to like, calculuses, Calc 12s, itemized list of assignments with grades. So how that deals with me is I'm a head football coach. And so we deal with, being eligible. So our eligibility list that we pump out every 2 or 3 weeks is based on that. So part of my job as a head football coach is to make sure kids are eligible. So, okay, I can access and see, I have kind of a classroom set up through Sycamore of just football players, and I can see what they have in those other classes. And then, but I can't see what they're missing. So that's kind of the hard part. So then I kind of have to quietly but toe the line and go find them and their teachers and get them all on the same page and be like, okay, you're missing 3 assignments, get them turned in by this day so that way you're eligible for the next week. But I also got to make sure I'm not just having casual conversations about kids' grades out in the hallway, even though that's kind of what I'm doing, which is in my plan period. That's what I do is I go walk around the school and I chase kids down. But I mean, that's how I deal with it on a daily basis.
And I'll touch on that. Like as an administrator and somebody who worked in technology for 6 years, that's a common, we expect like an academic interventionist to be able to work with kids and pull up grades and things like that. But at the same time, and not necessarily even me, but it's, upper administration pushes back on who gets the access. So you have to be creative about, we understand as a football coach, you're checking on kids' grades, but there's a creative way to do it without allowing access to the whole, everything, you know what I mean?
Luckily,
It's
my
more, it's to protect it's protect the teachers as well, because
yeah.
we don't want them having access to everything, I guess. And that's the
Oh yeah.
double-edged sword of it.
Yeah.
Anything else on that slide, or should we move on to the next one?
Let's move on.
So kind of the notes I took here, kids that under 18 can't consent to having their information released. And if you read through the chapter, a lot of the violations of FERPA would be like publishing student directories that have too much information, where we've ran into it in Sioux City, being a large district, and especially in the last decade or two, is social media. And we have a flag that pops up on our Infinite campus. A parent can actually opt out from their student being in any social media type postings or advertisements for the school. Because on one token, we want teachers to promote what they're doing in their classrooms using Facebook and Twitter and other social media platforms. Yet we have lots of students that families don't want their student put out there. So when they do online registration, they can opt out of that consent. The consent is implied, I guess we'll say. If you don't opt out, then you've implied that you consent to using your students in certain regard, but they can opt out by signing a form that says they don't want to be involved in any of those. So, and then when you pull up those kids on our student information system, it says media objection. So we don't release any of that information anywhere on the web at all. So, and that's kind of my take on that slide. And I wrote down, do any of your schools have similar policies, practices? Do you have any examples from where you're currently at that consent?
We have ours is similar. Like we have pretty much check the box if you do not want the consent. And then we do have like a PTO, it's run by the PTO, their directory, since the directory information, if they provide it, there was like a really good table, I think in that section, like one of those upcoming sections, 7.1, where it like said, here's what goes in educational records, here's what goes in a directory. And like, you can release directory information. The parents just have to say if they object to it or not. So we have kind of the same protocol. And then we also, which kind of comes later, but we do have like within our student handbook that they have to sign to say they've, said and read it so thoroughly. It has a section on FERPA. And I included just like our page long excerpt on that. And I put it in our discussion question. Like I linked it there just to see like, what does it actually look like? If they were to go through, since we have to, according to the act, you have to like every year keep that updated.
Yeah, we do kind of the same thing with the student handbook as far as consent. Paperwork just gets sent home. Your student handbook needs to be signed and returned by a certain date. And then I think as far as like social media and technology being posted, like pictures of on that kind of stuff, I think that's just applied consent like we talked about. And then parents have the right to obviously not give consent or fill out something that says there's consent is not given. Because when I first came here, I kept seeing pictures online and there's a few students where their faces were blurred out, and I had never seen that before. And I guess it was just a privacy matter between the family, and they didn't have to be posted online.
Ours is the same. It's a check yes or no in the school handbook. I know our school is super, super strict. I mean, teachers are not allowed to take any pictures of kids or anything like that on social media. I know I see some schools online where their teachers like posting things in their classrooms and things like that. That's a big know in our district.
We have similar policies, as Evan and I, and we're kind of the Wild West being a private school, I guess. We can kind of, we adhere to some things, but it's kind of part of our, I guess, culture, especially in our elementary school classrooms. They're big on picture taking. I think it's kind of like daycare in a way that everybody likes updates about their kids. And I think that's the way some of those parents view it. But I know I can pull up on our school information system, we can pull up each profile of a kid, and it'll have like a little icon in there that says whether they're able to be posted on social media or not. So very similar.
All right. Move on to the next slide. I kind of just wrote here, yeah, it's violating FERPA it can be serious. I think most of us, most educators and most schools probably take it pretty seriously. Maybe they don't fully understand the actual law, and I don't fully understand everything in it, but we do things like I just wrote down, we only allow access where it's needed. We only put a certain amount of information in emails. I don't go into great detail. We have most common practices. We don't even use student names. We use an ID number. When talking about students in emails, because it's all public record. And so I guess we take steps in Sioux City to protect that student information. We don't post grades in public. That's a violation of FERPA. As far as I know, we don't have a directory of student information that's accessible. You can't go to the website and find out what students are enrolled in a school, things like that. Is there any tips that you guys have or practices that you do in your daily classroom that you use to protect yourself and protect student information?
You got me thinking. We're required, like, if you're emailing about a student, you have to, like, in the subject, use initials and things like that. We use Apple Classroom, so we're like screen mirror our laptop or iPad up. Like, that's how we project everything. And I mean, it's easy if you accidentally have your email up that you can click out of it right away, but it says a kid's name on it. That was kind of the main reason for that.
That's one of those practices that you don't even think about. It's because of the FERPA Act. That's why administration has those policies in place. But yeah, that's the same thing we do, is just we use initials in our emails, and I never even asked why, and I never, did otherwise. But I just, now a common practice is just using the initials in the email, and it's just what it is.
All right, let's move on to slide 5. So yeah, that annually we go over this stuff with students and parents. It's all in the online registration. One thing we did, as a principal, we get a lot of, especially at a virtual school and in Sioux City in general, we get a lot of kids coming and going and like moving districts. And I'd always direct them to my registrar for an official request before I release any information. And a lot of times we get calls from grandma or aunt or somebody related to the student. And if they're not on the official Infinite Campus or student information system, then we can't release any information about grades and things like that. So we do take it pretty seriously. And, we get parents that are in custody disputes, and it depends on, they have to be officially listed as a guardian or somebody who can receive information for us to release that. So I don't know if you have experience with those policies or if that's something that it just didn't have to deal with too much as, classroom teachers.
We actually this is the first year, actually. This was my 13th year of teaching, and we're a pretty small school. So we got like 30 kids per class, like boys and girls. So there's not a whole lot of, you know, issues or situations where that would occur. But we did have kind of a split household dispute this year where biological mom had like a lot of restrictions on what she was allowed to get. And so that was interesting because she was biological mom, but you know, they had a pretty protective case in terms of this student not being able to contact her via this or that. And like everything had to be very supervised. And so even like, I think she may have had access to certain grades, but we were not supposed to email biological mom. We were not supposed to contact her about that student because that was biological dad and stepmom who were in charge of pushing that information onto the next one. And then on top of that, what made it a little more complex was stepmom is a staff member here. So that was kind of an interesting little blurred line that we kind of had to deal with. But that's the only time in 13 years I've had to deal with kind of a family privacy thing.
Mine is pretty similar, and it's been custody battles and like mom or dad living in a different state trying to get information or grades and things like that. And they were actively in court, and things were always changing. There's a restraining order, now there's not. So I was just taking everything to admin and just kind of getting advice before I responded, or there was times where admin would just take care of it for me. So
And as an admin, that's your job, is to try to work through those difficult situations. And last slide, I know we gotta go quickly here. So the big thing we do in Sioux City, we have a lot of languages that are spoken in our community. And when we send out like official communications, we take great care to have all those translated prior to sending out. And then we also I used a program called Blackboard, which automatically translated every message I sent out based on, again, the parent does online registration, selects their home language, and then program automatically translated like mass communications that I would send out. You send out like a written letter, we have to have it translated in like 6 different languages prior to sending out. And that's a parent right, and that's in that FERPA law. It's just part of the law. And I guess, do you have any methods like that you use in your districts, is all I put on there. Is that your experience?
We're at a small enough school that we don't really have to deal with dual language parents, I guess. So I think our school in the past, if a parent has come in that needed to speak another language, they actually just went and got our art teacher, who was bilingual, and she ended up doing the interpretation. But otherwise, yeah, I think the schools just have to provide some sort of mediator there.
we're required to hire a translator or to provide a translator.
We use a Spanish teacher. Being in Fremont, we actually have a very large number of non-English speaking families. And even though we're a private school, in the last 10 years, I'd say our non-English speaking population in our school has probably tripled, I would say. The kids, for the most part, are in a pretty decent spot as far as speaking English, but parents, there's a lot of times where it's a non-negotiable. There can't even be a conversation without our Spanish teacher being present. And we're kind of we're an entity of our town parish. So like St. Patrick's Parish in Fremont is in charge of Archbishop Bergen Catholic School in Fremont. And a lot of communication that gets sent home is usually, since we have a heavy Hispanic population in our church, it's sent out in both English and Spanish. So just out of a courtesy, we don't have to. I think it's just more along the lines of they just want to feel like they're welcoming them and making sure that everybody's needs are taken care of.
Excellent. That concludes my slides. We'll move on to the next group.
Okay, the next portion is the rights of parents, which they do have the right to inspect their child's record. And that a school official should be present. That's the most important part I felt like seeing, is the school official should be present. And then while they're interpreting that information and asking questions, they can challenge the accuracy of any of the information that is in there. And there's like different steps then to take along the way. So if they challenge it, then the schools have to schedule a conference. I feel like there was like one magic number in this section, like everything has to be done in this many days or less. Anyone want to take a guess at how many days you think it is?
3.
Oh, there's 2, 3. Okay, 3. So everything in this section was like 10 days or less. So schools should schedule a conference in 10 days or less. Technically, the act calls for 45 days. But I think we kind of know that that seems like a pretty extended amount of time when you have a parent request. And I'm sure they'll keep getting on you if you're not doing it within that 45 days. So their recommendation was 10 days or less. And then if the parent is still not satisfied, they can request a hearing. But again, it's that magic number, 10 days or less. And then there has to be a final decision after the hearing, 10 days. So everything I kind of think of this section is like, just get everything done within 10 days of each process. And it could go to civil court if that's kind of where it leads. Anytime there is a release of records, there is a written form. You have to have all the required specifics. I also kind of found it interesting that like anytime you're even sending like records to another district, parents are always notified. And I know that they're probably going to notify you that like, hey, my student is moving to this district. And you would just think it's implied, but there really needs to be like, there needs to be a notification that it is being sent to that district or place. Has anyone if they know, I know maybe as a teacher, you wouldn't know if there has been any contesting from parents and how that was handled within your school or district?
The only things I've ever experienced as far as contesting would be like grades and attendance. It's oftentimes dispute attendance.
Like the actual amount of absences.
Correct. Like if my kid wasn't absent on
Right.
so-and-so day, and we have to kind of go through and I've had to go as far as get the recording from the class, and we're talking virtual here, but it's a little easier in person. But I can't change the attendance. I have to get confirmation from the teacher that the student was there or not there. We used to deal with that in study halls of 80 kids. Well, the teacher just missed a student, and now there's a dispute in the attendance. But those are the most common disputes. And then, grades and things like that. Maybe credits on a transcript. Those are the common disputes to educational record.
Yeah, I think attendance would be hard to, I mean, like you said, you have a virtual setting, so it's maybe different, but it would be hard to like say, like dispute that and be like, no, they were not in class. Because it's kind of like a he said, she said. So I think that could be kind of challenging.
Well, we had a camera on policy, and if they're more than 5 minutes late, they could be counted absent for that class, and then record all lessons so that I could actually go back and prove whether or not the kid was there. So
Okay, the next piece, Dave kind of talked about this a little bit, but the rights of non-custodial parents, because as we know, there's sometimes controversy between non-custodial, notice it says like biological parent. So there was like an example within the text that had a court case where a mother who had the custodial rights, biological parent, did not want the non-custodial biological father to have any access. At the end, there was like the court proceedings pretty much said like both parents can have access because they're both the biological parents and they both are in the interest of the welfare of the student or the child. So even though one had custodial rights and one did not, I think that could be by situation. I think, some parents do have no rights to their no educational rights. I think if there's also anything within the court system that pretty much says like limits what their rights are, you would have to follow that. And I think that's really tricky, especially I think nowadays we have to kind of follow that line of like the parent said this, but is there anything really in place through the court of law that says otherwise? Because in this instance, it said give the rights access to both parents. It did emphasize how there should be a district policy on these situations. Honestly, I could not think of a district policy that we have. I wasn't really able to like find one when I kind of through the situations I've had with my administrators, they've never really mentioned a district policy. Does anyone have a district policy with anything with non-custodial parents?
Not off the top of my head, no.
Dig it out, and there may be a board policy, but I wouldn't have time.
Yeah,
Good up.
definitely have to go to administration, and they'd probably have to go to our district administration to make sure we were following everything correctly and making sure we follow if there's anything deemed by the court of what we have to follow. So that's one area you would definitely have to dig more into. And then it went into the rights of eligible students. This was touched on a little bit earlier, but pretty much they have the same rights as parents. Once they have reached that age of 18, they can again inspect their own record. They can challenge any record. They can request a hearing. So all of the same parent rights take place also with student rights once they reach the age of 18. And then this is kind of the big one where we feel maybe we fit a little bit more is the rights of school personnel. So teachers, counselors, administrators who have a legitimate educational interest can view those records. And then it goes on to say that it should be a written form that shows the maintenance of, what files were reviewed, who reviewed it, the date they reviewed it. When I was in OPS, every time we went into, we called it the CUME record, as a teacher, we would have to sign date and put that information. It was just like on the front of the folder, and it was just like a running record of all the people that viewed it and checked it out. However, now as a reading specialist in my new district, I go through and view like 60 to 70 different records to put in reading plans. And as far as I know, I've never signed anything. I've never dated anything. I've never shown that I've put these records, and I didn't really view, I guess, the records, but I did add a plan to the record. So I find that really interesting that I'm just kind of like, yeah, you can go back there and put those in there. And I tried looking in like my staff handbook or my building kind of basics, and I could not find anything that indicated like how you review or check out records. And I know sometimes teachers take like their whole class once at the end of the year and they like complete them. And I'm not sure if there is any type of check in, check out system. Does any of your schools have like a system for viewing records?
It's another one that's not on the top of my head. I'd have to look into that a little bit more.
I think it's a similar, and I didn't a lot of requests to look at it, but like at previous schools, if you needed to look at the permanent record, you'd have to check it out and then get it back and check it back in. So there would be a record of who viewed what. and where it actually went. We didn't want to get into a situation where somebody borrows the permanent record and then it doesn't come back. Something like that.
So I think that's important if you are doing that, like just probably find out what that, I'm like, I need to probably go back to my administrator and be like, should I have been actually completing some sort of maintenance form? Because that is a part of FERPA that we need to make sure we're indicating who is viewing those. And then the last piece is just referring to this amendment that emphasized that institutions are not prevented from maintaining records related to disciplinary action, especially when that could pose a significant risk to a student or others. So you can disclose it to the school districts or school officials. Some other parts that were kind of emphasized in this part of the text. One, I really appreciated there was a table that broke down like these are rights of students, these are the rights of parents, these are the rights of staff. And it was just a really easy to read table. Like this is what they can do. This is so you kind of know what your limitations are. And then the last part referred to a court case where a student had a disciplinary hearing, but he wanted to go back and view records that pretty much stated like it was a substitute teacher, like what was her role or action in this, and what did she do? And throughout the court case, it said that like you cannot go into records and view anything on teachers. So we are not afforded the same rights as students, so they cannot go into and look at those student or the teachers' files and see what a teacher did. And then it also mentioned a lot with all the digital era that we're in, that everything that we are referring to with FERPA has the same rights with digitized files. And just making sure those are being, kind of go back to what Dave said, like with his, like the technology part, be very closely monitored, and that you're following all the logistics that go with FERPA. Anything else on that section? All right.
I'm up. So this part of the chapter starts discussing confidentiality issues with school counselors, which if you think about it, I mean, your school counselor is probably privy to the most private of information that a student has at your school, probably even more so than the principal or superintendents or whatever, because they're literally that barrier between the student and the rest of the school, pretty much. You know, like in our school, we're a very small school, but we have one guidance counselor, and that guidance counselor is in charge of scheduling classes, dealing with social issues, you know, bullying issues or relationship issues, or you know, the issues of, is this kid going to take the ACT, getting into college, bringing in all those other people. So, I mean, they're kind of the liaison of all of our students. And so they get a lot of information. Parents call them, students see them. And so dealing with that confidential information is important. So a number of states have passed laws protecting confidentiality of school counselors to make sure that they're taken care of, but most states don't support them with the protect that confidentiality protection. So most of the states do not. Most communication between a school counselor and a student does not rise to a civil or criminal proceeding for the most part. I think that's probably due to the school counselors having a good moral high ground of not just sharing information that they shouldn't, or putting students in a bad position to where those civil or criminal proceedings would be necessary. But also, I think it's similar to maybe seeing somebody's psychologist and putting them on the stand for something they wouldn't need to unless they absolutely have to, because of that privilege that exists there between that person that the student is confiding in that situation. And that's I think it's important for the school to have a person like that a student can refer to file complaints or bring issues to them without fear of something becoming public. I know that's a big thing we've dealt with over the last decade, which is cyberbullying, bullying, and all these other issues that, you know, you want people to deal with the issue, but you're also afraid of the social recourse when someone complains and files a complaint. So go to the next slide. Building on that, in states where no privilege is granted, the counselor is required to testify if ordered so by court. But counselors don't have to share what they learn from students with their parents. Again, I think that's a kind of a token confidentiality and a person of trust. The counselor will probably just leave it up to the student to say, hey, you know, like if you're having this social issue with this person, like a boyfriend or girlfriend, or someone's bullying you, that's not necessarily the counselor's job to call the parents unless the student wants them to. Maybe they want them to do it for that person, but you know, they're not going to go play the parent role in that regard because it's not their information to share. I think that would probably ruin the trust between the student and the counselor if they kind of went around their back, or if they did it without them letting them know. Documents and sole possession of counselors are not subject to FERPA. And then the confidentiality is also not absolute, which means there is a need for public disclosure if the public needs to know and that information needs to come out, it will come out. And so your confidentiality is eventually nullified. So if something were to need to go to a court case and it needs to become public knowledge, then it will. Part of this is it came up in a very interesting but also tragic court case in 1976, Tarasoff versus Regents of University of California. A student confided in they didn't really say school psychologist, but I think they implied school psychologist, that this student wanted to kill another student. That school psychologist in turn alerted campus police campus police, but did not inform the student in which the threat was intended to. In turn, that student was murdered. And so the court held that psychologist should have warned the victim. That directly impacted that person. Obviously, they were murdered, but they should have alerted that. I mean, that's a very extreme example, but I think what they're getting across there is if there's a threat that is shared with somebody like a counselor or a psychologist, then it is kind of their, you know, professional duty to pass that information along, moral duty to pass it along. So, I mean, has anybody dealt with that in terms of having to almost, I guess, break privilege or feel like it needs to be shared just out of safety concerns?
I think the big thing for teachers is, you know, we're all mandatory reporters. And in our school, we hand out, our guidance counselor handed out this yellow piece of paper. I got it hanging up here actually, and it says, it's a big check mark, and then it says check and connect. And that basically means, you know, we're a safe, if we have that in our room, we're willing to talk to you, we're a safe space, but at the same time, we're a mandatory reporter. And if anything, if we think a student's going to harm themselves or someone else, or has to do with anything that goes against, you know, education, the environment, you know, then we have to report that. So
Same counselors here in Sioux City are expected to protect students and other students if they, you know, and mandatory report anything that needs to be reported. So there's a line of things they can say and not say to a counselor that are going to get passed on to the next step.
And my situation is a little bit different, but in my previous district, we had a situation where a teacher was arrested for inappropriate behavior with a former student. And because it first went to trial, they did go back and had to speak to many of the other teachers, including the counselor in my school building. And they were at that point going to be required to testify because they had enough information. But it goes back to one, some of them, it was not because of things a student told them, but other things they happened to see that was questionable to the safety of that student and the fact that it was like a current court case against a teacher. So they did have to, I think they ended up settling, and he ended up saying he will not go through with the trial, and just to not like put everyone through that. But in that case, we had multiple members in our building that were required to testify.
I think it's interesting to look at too, like just as a teacher, I'm not from the administrative side, but when you're alerted, for example, that, you know, I have finally, eventually you're like, you hear, oh, this student's being bullied. And you're like, well, okay, when? Now that I know, I can find out locations, I can find out when this is happening. And once I'm alerted to it, then I can find out. And so, you know, sometimes that puts kids in a bad spot where they're going to the counselor, and is the counselor supposed to pass that along to, you know, because then do I approach it? You know, some of my best work as far as interventioning a bullying situation is actually citing previous examples of bullying where I approach the kid and I'm like, listen, you've done this to this kid, you've done this to this kid. And then I guess, and maybe I need to be more careful with that now, because maybe that information was not supposed to be shared with me, or I was not supposed to approach the kid about that. But it has worked, because then I'm almost like throwing evidence at the kid and being like, this is what you've done and it's going to stop. But also I wouldn't know if I wasn't notified. You know, it's now that I know, I can look for things and I can stop it or stop it before it even starts, prevent it. So going on to slide 14, we have the enforcement of state or federal statutes. Federal officials and state officials may inspect files without parental consent in order to enforce federal or state laws, or to audit or evaluate federal education programs. I think this would include any sort of federal investigation, kind of supersedes any sort of confidentiality that you may have, stuff being brought into court. You know, if there's a hate crime or a school shooting or a threat of school shooting where, you know, I guess I want to say the jurisdiction kind of gets passed on, then you have to abide by those rules. I guess there's kind of a hierarchy of needs in terms of confidentiality and keeping information private. When you put, and as almost every single chapter I think that we've read, kind of the fall to is, you know, your excuse of doing something is if students are in danger, or if student safety is at risk, then this must, then all of a sudden your rights kind of go by the wayside. And that kind of takes us into slide 15, where it says, in these cases, personally identifiable information may not be associated with any students unless Congress by law specifically authorizes federal officials to gather that personally identifiable data. So that means Congress actually has to pass a law specifically stating, okay, go get this information that can be personally identifiable to a student. And the first one that pops into my mind that maybe that would occur, because I'm not a huge case law guy, I guess, but is the Patriot Act, which we kind of just read about here recently, which could be like an umbrella statute, I guess, that, you know, yes, some of that private information is private, but if there is a threat of, you know, terrorism or whatever, that kind of, they deem that as subservient to what the needs are of the federal investigation. So Congress, you know, we had all these rights, and then Congress decided following, you know, the attacks of 9/11 that there needed to be, you know, these situations taken care of. And the only way to do that was to go kind of beyond the reach of finding more information, and they needed to pass a law to do that. So anybody have anything to add on to that? And that takes us to slide 16, where authorized representatives, these are the people who may access records in those situations. That one of those would be the Comptroller General of the United States. And I was today years old when I figured out that even existed. And so I actually looked it up. That person who is it's a job for the US government. His name is Gene Dodaro. And this is basically the person who works for the government who gives Congress and agencies timely and fact-based information used to improve government function and save taxpayers billions of dollars. So there's your bits of information that you did not know today. Maybe you did, I didn't. And then the Secretary of State, as well as the administrative head of an educational agency, you could think of, you know, the U.S. Secretary of Education or the Nebraska Commissioner of Education, Dr. Maher. And then you have state and educational authorities, State Board of Education, Nebraska Board of Education. So those are the 4 authorized representatives who would access those bits of information.
Okay, so now I get to talk about privilege and good faith. And I feel like I'm kind of the opposite of what we just kind of learned about. Not necessarily the opposite of FERPA, but you know, we just, in these first few weeks, we keep talking about policies and having our ducks in a row, I guess. And that's kind of with FERPA. You can have all these policies to protect student information and teachers' information and, you know, have everything squared away. But now I feel like with privilege, we have to make policies to get around those policies if information is requested. So exactly like what that says, this slide, sometimes whether it's law enforcement or we talked about parents, whether they're biological parents or custodial parents, maybe the guidance counselor needs information. Well, we need to have policies in place to make sure we go through the correct chain of command to get that information. And on the next slide, when such requests are made, we must make sure it's protected by a qualified privilege. And qualified privilege is the right to make a statement or report without being held liable for defamation or other legal claims, as long as the statement is made in good faith for a legitimate purpose. So when I think about good faith, with, you know, if let's say I'm talking to a student and we just talked about being a mandatory reporter, well, what I tell my kids, when you have good relationships with students, they're likely to tell you things, and, you know, it does borderline the professional and friend. And what I tell my kids when they start talking, and, you know, they might be talking about their weekend or whatever they're doing, and I'll tell them, like, guys, I love that you talk to me, but if you say anything that I don't want to hear, I'm going to tell somebody. I have to. You know, I'm here to protect you guys, and I'm here to protect myself, especially. So when people start talking that locker room talk, that's what I think about when I think of, you know, privilege and good faith. And obviously that's just the surface of it. And students, you know, if they you brought up, Seth, a great point about a student told a guidance counselor, I believe you said, that they wanted to hurt somebody and then they ended up murdering that person. So that's what I think about when I think of being a mandatory reporter and kind of protecting yourself. Anybody else have anything to add on that one? So the next slide, good faith requires that it's a legitimate purpose. Common interest in the student's well-being could constitute a legitimate purpose. And then I kind of just highlighted tattling. I feel like as teachers, we get that all the time, you know, that kids are going to tattle. And we need to make sure that when kids are telling us something, that we do take it in good faith, because we don't want those students to not come back and talk to us anymore. But then it could be a situation where it's like the boy who cried wolf, I guess. You get that student that tattles over and over and over, and you're not going to want to take their word, and it's not going to be credible anymore. So that's what I got.
Yeah, kind of one of my main takeaways, kind of from what you were saying, but also kind of what everyone has been saying, is going through the proper steps in documenting things and reporting things and going through the necessary steps to protect kids' information and things like that. It's not convenient. It takes more time, but it's necessary to do it every single time. That's just kind of what I've personally taken away so far. So we'll wrap up with acts of malice. So there are two different types of malice. There's actual malice and implied malice. The main thing that malice kind of deals with is you have to look at the intent. Was there intent there or was there not? So was there intent to harm or injure another person? So an example of like implied malice would be like a derogatory comment to somebody or calling somebody something. And then actual malice would be like whoever was offended by something, if they can prove that the offender was strategic and intended to harm them, so make something up or say something about them that would defame them, if they can prove that there was that intent there, that would be an example of actual malice. Me personally, I can't think of any like actual examples of malice between a staff member and a student, like a staff member saying something about a student. One thing I can think of is there's one of my coworkers didn't have the best relationship with a student, and that student had like asked them what their grade was on something like out loud to the entire class. And my coworker was basically like, come up here, and like so they could like whisper it to them and kind of tell them. And the student's like, no, just say it, I don't care. And the teacher said it. And the student went home and told mom or dad that their teacher like was trying to make them look bad in front of the class. Thankfully, because I do believe the teacher's story, but so did the parent. But if the parent didn't, that could get kind of dicey with malice and kind of determining if there was an intent, because I think it's pretty hard to I guess I should say, I guess that's where having a good lawyer would come in handy with something like malice, because it's kind of hard to prove intent, I think. So I thought that was kind of interesting. So that was really the only example I could think of. Do you guys have any experiences with that?
I don't have experience necessarily with malice, but I do know like when it's that time for teachers at the end of the year to write in each of the students' records, that, we're being very explicit when like I'm mentoring teachers, like only give the facts. And I know that was kind of mentioned in the textbook, like don't make all these observational things that you just like kind of, you can't prove with something. So I know, because we're like, anyone could request to look at that student record. So just make sure you leave it to the facts rather than your feelings toward that student.
Yeah, I'm glad you bring that up, because we were trained like recently, specifically, and like I'm only going in my 5th year of teaching, so I remember my first year teacher meetings pretty well. But whenever there's like a behavior or something, like if you send a kid to the office, you have to type up a behavior referral, and you are only supposed to give facts. You can't give you don't want to show like any emotion or anything and like that. Just say exactly what happened. So I guess that could kind of protect against that too. So I'm glad you bring that up. You go ahead and go to the next one there. This one talks about truth as a defense for liability. So the way I interpreted it is if you are telling the truth and there is no ill intent, that can kind of protect you from malice, but you can still tell the truth about something. And if you had bad intent, you were trying to make the person look bad, then that was deemed malicious. So I thought that was kind of interesting there. It goes on to say school personnel should exercise care in ensuring students communicate to others free of malice based on defensible evidence, communicating in a professional, non-biased, and truthful manner. So that's kind of what I think of, especially communicating to admin or via email or documenting things to just kind of stick to the point there. There were 2 court examples with malice that I thought were interesting. There was one in New York where a school district was able to share scores or test scores rather, as long as they didn't include names of students. And then there was one that kind of went back and forth in Illinois where a group of parents wanted to see or compare school districts' test scores with other districts, like standardized test scores. And for whatever reason, the school district was refusing to release those scores. So it kind of got me thinking, man, if there's a school who, if the reason they didn't want to release the scores was because they didn't really like their scores compared to other school districts, if they didn't want to look bad, they could use these FERPA laws to kind of protect them and say that it's in the best interest of the kids to not release those scores. So just kind of getting into the weeds and seeing kind of how people are using these laws to kind of go back and forth there, I thought was interesting. It went back and forth in the Supreme Court, and the school district eventually was required to release the scores as long as they didn't release any students' names. So that's kind of how that ended. So the main takeaway with malice is just kind of determining the intent. If there's intent for defamation, then it's malicious. If there's not, and it's the truth, and there's not the intent, then that's kind of the protection from malice.
Okay, that is chapter 7 on liability and student records, and really the specifics that go into the Family Educational Rights and Privacy Act, and just also making sure, I think we always go back to policy, checking what your district policy is on a lot of various scenarios that there may be.